Okay, all right. So, um, to my students, I'm really tired of talking straight to the computer when nobody's there. So I'm going to talk to my husband, who you can't see, but he's over there.
Hello.
You see, I'm not talking to myself, and then my dog is over there, so she's asleep. So it's just like class, right? He hasn't read the material either. Oh, it's funny. Yeah. My jokes are for me. You guys know that. If anybody else wants to laugh, they're welcome to it. Otherwise, they're for me. Okay, so this chapter, Trent, is on civil rights and the Constitution. Civil rights is very different from what we've gone over thus far in this class, because civil rights is very different from civil liberties. But before we go into it, I just kind of want to remind you, there's always, before we go into a particular new section, we just got through with the rights of the criminally accused. And so we're going into a new section, civil rights, and because of that, your authors put together an introduction for you. The introduction in this case is super, super important for you to read. Okay, so read the introduction because it provides you context to the levels of scrutiny and just some really important parts that you need in order to understand the rest of the cases. Luckily for Trent, or for those of you who haven't read it yet, I'm going to go over what those things are, the important parts of that introduction. So that introduction is what you see here. It's page 556 through 563. And then it kind of, my dog made a noise. And then it kind of gives an overview of what the next few chapters are going to be. So chapter 12, what we're talking about today, that's the 14th Amendment and the Equal Protection Clause, but specifically race discrimination. And then on chapter 13, we'll talk about levels of scrutiny and other types of equal protection. Basically, you'll learn that the Supreme Court gives certain groups of people really, really strict protection in terms of discrimination, but other groups, they've been really hesitant or reticent to actually provide those protections. So, moving on. All right, so civil rights and civil liberties. What are they, and why am I specifying that this chapter is about civil rights? Well, because civil rights are protections by the government power. It's the obligation imposed on government to take positive action. So it's about government taking action. That's what rights are. Government stepping in and saying, you can't do this to the states. Okay? So civil rights require government action. It concerns equality, and it's bolstered by the 14th Amendment. Civil liberties, on the other hand, what we've talked about thus far, are constitutional protections from government power, like freedom of speech or the right to privacy. You find that this type of protection against civil liberty requires no government action, and it concerns freedoms, and it is bolstered by the Bill of Rights, so the U.S. Constitution, right? Now, neither civil rights nor civil liberties, I think I talked about this in the very, very first part of the semester, are actually discussed specifically in the U.S. Constitution. But nevertheless, we see that the court rules on them.
Wrong button.
I know that now. All right, so 14th Amendment. 14th Amendment is the basis for our incorporation of the Bill of Rights into the states, and it's also the basis for civil... did I get that mixed up? Yeah, 14th Amendment is, it's the basis for both civil rights and civil liberties, right? Civil liberties being incorporated to the states, and then civil rights too. Now, just in general, there are 4 sections, and we really only pay attention to a couple of them. One being the Citizenship Clause, Due Process Clause, Privileges and Immunities Clause, Equal Protection Clause. Those are the most significant. Section 2 talks about the requirement that former slaves fully count for representational purposes. Okay. Universal adult male suffrage, and then 3 talks about states that rebelled, and then 4 is even more boring. It talks about public debt, except for those of you who are majoring in maybe economic development or the economy. That might be. Anyway. All right, so we're going to focus on 14th Amendment, Section 1, and all of these clauses, all right, are important, I guess, in general. You should read the Constitution, but the primary focus for us is going to be on this bottom, the Equal Protection Clause, and that says, nor deny to any person with its jurisdiction the equal protection of laws, notice that when it's saying not to deny, it's talking to states. So no state shall make or enforce any law, no state shall deprive, no state shall deny any person in its jurisdiction the equal protection of the laws. So, all right, now you might remember too, Trent, that when the 14th Amendment was incorporated when the Bill of Rights were incorporated by the 14th Amendment, a lot of lawyers tried to use multiple parts of the 14th Amendment to try to justify that. They tried the Privileges and Immunities Clause, and the Supreme Court is like, nope, that doesn't apply. And then they tried the Equal Protection Clause, and the Supreme Court says, I'm pretty sure that that doesn't apply. And then they looked at the Due Process Clause, and the Supreme Court said, there you go, you got it. Now the Bill of Rights apply to the states. Now, for civil rights and equality, obviously it makes sense that they're going to really focus on the Equal Protection Clause. So again, that's what we're going to focus on, Equal Protection Clause. That's the wrong button again. Okay, so what does it mean to deny equal protection of the laws? There are basically it's a two-pronged test that the government uses when they're asking the question, or if they're looking at a case that somebody's claiming discrimination, they're looking at two things. First thing is, there has to be discrimination of some sort. And we'll have to kind of parse that out a little more as we go through this. So there must be some sort of some sort of way to demonstrate that the law in question classifies or treats one group less fairly or less equally than other groups. And then the second prong of the test is it has to involve state action. So if you remember in the previous slide, we have the Equal Protection Clause. All of these talk about the state. The 14th Amendment is focusing on the states. And so it matters that there was state action that is involved. Specifically, it matters that there's, sometimes we use the word state like for federal when we discuss federal issues, but in this instance, we're talking about like one of the 50 states, the states. So there has to be state action. State or local governments have enacted, or it can just be that maybe they didn't enact a law, but they're in some way supporting discrimination by somebody else. So just kind of parsing out discrimination a little more, the Constitution prohibits not just discrimination in total. In fact, the Constitution specifies that some discrimination is actually reasonable. What this discrimination is focusing on, or what's unconstitutional, is invidious discrimination. So this is discrimination that's arbitrary, that's capricious, in its unequal treatment, and a state can't adequately justify why it's doing it. Looking at discrimination, that whole idea of is a group discriminated against? We see that depending on who the group is, the Supreme Court treats different groups differently, all right? So if the Supreme Court has put a group of people in what they call a suspect class, then that suspect classification receives the highest level of scrutiny available to court cases. So these are, so who then are those involved in suspect classification, or who are those that are classified as suspect groups? It's any group that have faced discrimination historically, intense discrimination historically. Again, historically disadvantaged, and then is the trait inherent? Is the trait highly visible? And the court has deemed that race, there are four things in the suspect classification, Trent: race, religion, national origin, and alienage. Alienage meaning that,
Not a citizen.
not a U.S. citizen. Yeah.
Are they a citizen or not?
Yeah, good job.
Yeah.
Alienage means whether or not they're a U.S. citizen. That's what he said. You got the right answer. I want to make a note before we move forward. In the footnotes of your text, your authors say a lot about Caroline products be U.S., or U.S. be Caroline products. I actually think I have it backwards, but it was in 1938, and it's actually in this case, which, by the way, has nothing to do with discrimination, that the Supreme Court begins to, or at least hints at the fact that there are some cases or some groups of people that require more strict protection from the government, right? And it's actually, you'll find It's the footnotes of US v. Caroline products. It's not even Carlene. I've completely misspelled that. It's Caroline. So, sorry about that trip. So anyway, in the footnotes, you will find that that is where we get this idea that some certain classes have a higher level of scrutiny. All right, now, there are, if you remember, 3 levels of scrutiny, and we're going to talk about these. In general, discrimination is given rational basis scrutiny. It's the traditional test. It challenges, is the challenge discrimination or the challenge law, is it rational? Is it arbitrary? And there's a presumption with rational basis because it's the lowest level of scrutiny. The presumption is that the state action is constitutional. So the onus is on the individual to prove that there was discrimination. Age discrimination comes under this topic or under this type of scrutiny. Intermediate scrutiny, or we call it, sometimes it's called heightened scrutiny. It's the step above rational basis scrutiny, and it's a little bit harder to define, but if there is there's certain groups called quasi-suspect groups. We have determined, not me, the court has determined that sex is a form of quasi-suspect classes, right? So, women getting equal treatment in the workplace, that sort of thing. And this is about important government objectives and that have to be substantially related to achieving some important government objective. So it's just a heightened approach. And then strict scrutiny, of course, is the highest. This is the one that we look at over and over again. The state has to have a compelling government interest, and they have to have the interest in, let me back up. Compelling government interest, and whatever law they enact to achieve it, they have to enact it with the least restrictive means possible. There, that's that well. All right, so the presumption here, though, with strict scrutiny is that the presumption is that the state action is unconstitutional. And so race discrimination falls under strict scrutiny. Remember, all this is found at the introduction, so you're really going to want to read the introduction. The second requirement, first is discrimination, and certain levels of discrimination or certain levels of classes have different levels of scrutiny. The second requirement is there has to be some sort of connection to the state, right? So the state has to do it. Generally speaking, the 14th Amendment doesn't apply to private individuals, okay? So there has to be, note here, a statute enforcement and administration, any action of state officials. There's no element of state action that can support invidious discrimination. So note 2, again, reminder, equal protection clause only applicable to the states, not the federal government. Congress's role in equal protection. So there's been kind of a push and pull of, let me back up. So we've come a long way with civil rights, okay? And all of our different branches of governments want to take credit, for, especially the elected officials, for the strides that have been taken in racial integration and anti-discrimination, be it legislation or be it case law, that sort of thing. I would be remiss, though, if I didn't mention Congress's attempt to achieve racial equality. So we have a lot of tries. Now, I'm going to tell you, and though your authors don't say this outright, my view is that if it wasn't for the court, if it wasn't for the Supreme Court, we probably wouldn't be where we are today. And here's my reasoning why. Now, I know the court's done a lot of ridiculous things, like Dred Scott. In Dred Scott, the court literally said that African Americans weren't citizens, and that was like in 18-something, okay? 1896, I think. But Congress has a history of at least trying. But their tries are, none of them really worked really well until the court really, kind of battened down their hatches, so to speak. So in my assessment, and in others, it's not just me as a judicial scholar, but in other scholars' assessments, the court's the one that really had the most effect. That's where, when we look at civil rights advocates, they'll tell you that the courts is where they found the most success. Nevertheless, remember, Congress was the one that proposed the 13th, 14th, 15th Amendments, right? So good for Congress there. They have multiple tries at civil rights acts. The Civil Rights Act of 1866, 1870, 1871, 1875, 1957. 1960, 1964, and then 1968. Did you know that Congress attempted it that many times?
No.
Yeah, most people don't. And the reason is because most of them didn't do anything. They just didn't have any bite to them, is what most people say. And I think there was a big reason they didn't have any bite to them. Probably the big reason was that they were afraid they wouldn't get reelected if they came down too hard on this. Now, there's a benefit with the Supreme Court coming down really hard on racial discrimination, and that benefit is
Elected officials don't have to take responsibility.
elected officials don't have to take responsibility. Unelected officials don't have to take responsibility. That's what I said.
Well, the elected officials don't have to take responsibility for what the court did.
Exactly. Yeah. So the court does something. The elected officials, maybe they secretly are like, yay, but then they don't have to say out loud, so they don't lose any constituents or potential votes. And I kind of think that's what happened here.
Or they can run on overturning the decision by putting.
It's true. This elected official in Congress can run on overturning the decision. Or if you're a president, you can run on trying to pack the court with more either conservative or liberal justices, which is what Nixon did when the Warren Court remember when the Warren Court really pushed for more expanded views of the rights of the criminally accused. They wanted the criminally accused to have more rights, and Nixon, one of his entire campaign platforms was on anti-criminal rights, that sort of thing. So anyway, so what did Congress do? Well, they did a lot, but I mean, they weren't really good. Where they really failed was trying to justify their involvement in it. Now, the Constitution did allow Congress the authority to legislate in these areas of race discrimination, but they didn't do a very good job of grounding it in the right constitutional basis. Congress has found the most success in terms of overturning, or I guess not overturning, but Congress has had the most success in trying to do away with racial discrimination whenever they tie the legislation to the Commerce Clause. So I was at a talk one time. It was a constitutional law talk, and it was right during the time when the Affordable Care Act was up before the Supreme Court, or not the entire act, but certain portions of it. So that was 2012? Might have been 2011, actually. At any rate, so the Affordable Care Act, and there was this big panel on whether or not Congress could just continue to use over and over again the Commerce Clause to justify every single thing they did. And these constitutional law scholars, and I think I've told you all this before, but they all came to the conclusion that, essentially that's what Congress can do. If they can tie, and somebody used this example, I remember specifically, Trent, that they can probably create legislation that says you all have to eat broccoli and Fruity Pebbles, not together, but at least those two things every day. And they could tie that to the Commerce Clause because you have to buy broccoli and Fruity Pebbles. And then they could root that as being constitutional. And the Supreme Court might agree. Anyway, so the fail-safe here is the Commerce Clause. And if you remember from your American government courses that the Commerce Clause was a big part of the Constitution that caused a lot of controversy. So let's move on. All right, now, we're not going to really talk about the 15th Amendment that much, but I'd be remiss if I didn't go over it. Remember that we're approaching the end of the semester, and that being said, we're not going to get into, I think it's chapter 14 that talks about voting rights, but I did want to talk about the 15th Amendment because it is part of the Civil War amendments that we're talking about here. 15th Amendment gave everybody the right to vote. Well, everybody. It gave African Americans the right to vote. Male African Americans the right to vote. Thank you, Trent. Yeah. And in addition, the second section here notes that Congress has the power to enforce that by legislation, whatever legislation is necessary. Okay, there were a lot of delays to the 15th Amendment, and I am going to skip over this actually really quickly because we need to move on to the meat of this. It was ratified in 1870, but it really wasn't implemented until 1965. Why? Well, because of elected officials. So what we see is a couple of things happening. Once the Civil War amendments were enacted, the nation got really distracted because the Industrial Revolution started happening, and because the Industrial Revolution started happening, we saw more political corruption. Anyway, the executive and the legislative branches, when they're campaigning, they just didn't really see it. It wasn't pertinent for their campaigns to really work on that. So we see the court taking up the mantle later. All right. Be sure to look at these other important amendments too. Moving on. All right, now let's go to the rights of the accused. I'm going to go a little out of order than what your syllabus says. Ouch. Plessy v. Ferguson will be first, but Shelley v. Kramer is actually at the very, very end. At any rate, just go with the order in your book. That's the order that I'm going now. Moving on. All right, now, I guess I don't really have to stay on this slide for very long for you guys to remember that the U.S. has had a history of racial discrimination, right? Specifically with the African American class or African American race, because slavery was allowed for years. And then once slavery was finally abolished, then there was institutionalized racism with Jim Crow laws and segregation laws. And at a time, I remind you all that African Americans were only counted as 3/5 of a person in the U.S. Constitution. Although also, I would be remiss if I didn't mention that a lot of our framers wanted to do away with slavery during the Constitution. As a matter of fact, this guy right here, you can't really see him. Oh gosh, that's my face. Anyway, this is Rufus King. He was famous for trying to add an amendment in the Constitution, or at least a portion of the Constitution that would say that slavery wasn't okay. Okay, moving on. All right, so SCOTUS, I know that I kind of talked up SCOTUS a little bit ago by saying that Congress was the ones that were really lacking on really pushing for equality. Yeah, I guess it was a group effort, if I have to say that. But I should point out to you that it was SCOTUS that determined that African Americans were not U.S. citizens, that literally African Americans had no rights that white individuals were bound to respect. So then we see the Civil War amendments that occur after. Sanford occurred, I think, in 1896 or 1870. It was the late 1800s, okay? And then we see Congress responds after the Civil War. No, Dred Scott v. Sanford occurred. Can you look it up on your phone?
Yeah.
It occurred way before, it occurred way before the late 1800s. 1857, I think.
1857.
1857.
Dred Scott v.
Sanford. All right. So that was pre-Civil War. Then we have the Civil War, and Congress reacts with the 13th, 14th, 15th Amendment. They were able to get it ratified because none of the southern states could vote. And we see post-Civil War Congress really tried, but they... Okay, now we're back. Where were we at? So we're talking about, Dred Scott? Yeah, and when we're talking about Congress acted, Congress kind of picked up the slack after Dred Scott, and then after Congress acted, we see the courts kind of balking again at things. So slaughterhouse cases rolled out the Privileges and Immunities Clause as a viable legal justification for anti-discrimination laws, and then we have the civil rights cases of 1883, which, oops, that's not a, there we go. So the civil rights cases of 1883 were cases that were grounded in the Civil Rights Act of 1875, which said that everyone's entitled to accommodation, public transportation, theaters, regardless of your race or your skin color. And again, the enforcement of this was based on the 14th Amendment, the Equal Protection Clause. But SCOTUS actually ruled that a lot of those actions, like transportation in a lot of cases, and theaters and inns, places where people stayed, that essentially they were private and it wasn't state action. So what you can see here is when a man has emerged from slavery, there must be some stage in the progress of his elevation when he becomes a mere citizen and ceases to be the special favorite of the laws when his rights are protected in ordinary modes like any other man. All right, now, the Supreme Court makes sort of a good step, I guess, but actually, no, they don't make a really good step here. You've all heard of Plessy v. Ferguson before, so I'm not going to go into the intricacies of the case law there, but what I am going to do is make sure that you understand what the significance is. So the significance is that after years of evading this question of what equal protection is, which SCOTUS did over and over again, they finally defined what equal protection is in Plessy v. Ferguson. And in doing that, they determined that things can be, or places, separate but equal is indeed constitutional according to the Supreme Court now. So Plessy v. Ferguson, as I'm sure you all remember, is all about the separate but equal doctrine being deemed as legitimate. It's not very professional to drink some DDP in the middle of a lecture. Okay, so basically what this did was, because equal protection was defined as, as long as the facilities were equal, or, the people could still be separate, it actually served to legitimize segregation laws and the Jim Crow laws that were already taken into effect. Now, I encourage you, actually, no, I don't encourage you, I tell you, and I encourage you, if you haven't done so already, you have to read Harlan's Dissent. It's one of the most famous dissents. Now, every once in a while, we spend a little extra time on somebody's dissent in a Supreme Court ruling, and oftentimes we find that they're really important because they're used later. Harlan has been, from this point at least, well, and this is the first case that he's really talked about racial discrimination, really consistent on his views, and he said a lot of really prolific things about separate but equal. And so let's move on to, oops, yeah, no, we're doing that. Okay, here we go. All right, so what does Harlan say? Harlan wants, and that remember is for you, that the purpose of any statute that's designed to exclude African Americans from white cars, not vice versa. So the purpose of that statute was to create inequality, right? It was aimed at one particular race. That the Constitution is colorblind and neither knows nor tolerates classes among citizens, and that the destinies of the two races, talking about African Americans and whites, are linked together. And anyway, we need to focus on we need to focus on. I'm gonna have to edit this part out. So Harlan notes that the destinies of the two races, referring to Caucasians, African Americans, are intrinsically linked, and so it's necessary for both of us to treat each other as equal. After this time, states, like I said, they were embracing the, oh, okay, separate is okay, it just has to be equal. But as states began to make more laws, they forgot about the equality part of the separate but equal. And so what we see here is that segregation was continuing, and there wasn't any focus at all on being equal. Now, during this time also, we have the establishment of the NAACP and the establishment of what we call now the Legal Defense Fund that Thurgood Marshall, soon to be Supreme Court Justice at this point, actually headed up. So, let's talk about Sweat v. Painter. So Sweat v. Painter is important because it starts to kind of, it starts to deviate from the separate can be equal doctrine that the court had before. This is about a gentleman named Sweat, wanted to go to the University of Texas Law School. Texas was kind of tricky in how he handled this. They didn't have an African-American law school, and they didn't want to admit him to the University of Texas Law School. So when he sued, the Texas trial judge delayed the case until they could the state itself could throw together some semblance of a African-American law school. Did you know that? Yeah. They stalled so they could do that. So they did some kind of like just kind of makeshift entity in Austin, and then later it was a little more official. They put one in Houston, so that once that was done, then we see the Texas trial judge taking up the case, and at that point the judge says, no, this isn't unconstitutional because see, you have another place you can go to sweat the African-American gentleman who wanted to have a law education. So the question here is, can a state discriminate on the basis of race in admissions to professional schools? This is the precursor to Brown v. Board of Education, but the focus here again is on professional schools. And instead of going in the decision, what I want to highlight are two things, all right, the significance. One is that we see the Supreme Court noting that separate is not equal in graduate level education. That you also have to account in the fact that, especially if you're going to law school, that you need to be able to interact with those people that you're going to be eventually interacting with whenever you go into the law profession. So it's about the experience too. So separate can't be equal in that instance. Now, like I said, the case pointed to graduate schools, but it kind of opened the door for Brown v. Board of Education and for separate, and it questioned whether separate can be equal in other venues just in general. One other thing, in both of these cases, well, actually in this case, is this what I'm thinking of? Yeah. So there's obvious differences in the University of Texas Law School and the Texas State University law for African Americans. But in their arguments, we see Texas argues that the Plessy precedent should definitely be upheld in its law school plan, and then we see Sweat arguing that the court needs to say something about the Plessy precedent, and the court explicitly refuses to say anything about the Plessy precedent, that separate but equal is constitutional. Instead, like I said, they explicitly say they're not going to, and they focus squarely on the decision that, assuming that assuming things can be separate but equal, in this instance, they're definitely not separate but equal. So the rationale, or the holding rather, was mainly about the law schools themselves being unequal. So SCOTUS doesn't overturn Plessy here. Moving on. Oh, I'm going to urge you to look at McLaurin v. Oklahoma State Regents. There. All right, so your book actually doesn't mention Korematsu, but I feel like they should. Well, they do, I think, in a footnote. Actually, no, they give it more than a footnote. But if later in law school, when you look at civil rights cases, there's a very distinct focus on Korematsu, which seems kind of weird because Korematsu v. U.S. was that case that we've mentioned in class several times about the constitutionality of the internment of Japanese Americans during World War II. You all know that SCOTUS ruled that the internment was constitutional because of national security. But in this case, they note that all legal restrictions which curtail civil rights of a single group should be immediately suspect. And so this, along with the footnote from Caroline Products v. U.S. that I mentioned in the introduction, together, these two create basically a legal standard that the Supreme Court is able to say now that anything dealing with racial discrimination is going to be held to strict scrutiny. And so when Brown v. Board of Education came up, that's exactly what they did. Now, once again, you all know what happened in Brown v. Board of Education, so I'm not going to go into a lot of detail about the case facts there, except to say two things, or three things maybe. First thing is it was unanimous, okay? The second thing was that it overturned separate but equal doctrine that was established in Plessy v. Ferguson. So now it's overturned, And the decision itself indicated that the ruling would affect areas of segregation other than public education. This was a real victory, okay? At this point in time, we see the NAACP, the LDF, we see individuals who were really fighting for civil rights, really being strategic in how they, in using the court structure to overturn, or well, not to overturn, but to address the problem of race discrimination, because Congress wasn't doing it. Now notice too that there are actually 2 Supreme Court cases that talk about Brown v. Board of Education. Did you know that? No. I think he said no. Okay. The first one was just simply the decision. This was a big decision. As a matter of fact, today, even, Brown v. Board of Education is seen as the probably the biggest decision that the court made in the 20th century. Not even probably, I mean, that it is. So the decision itself, SCOTUS knew, didn't lend itself from both making the declaration that Plessy is overturned and providing a remedy for it. So they decided to put Brown v. Board of Education on the docket again, but this time, instead of focusing on the constitutionality of separate but equal, they were going to focus on the implementation of the ruling. So what did they find? Well, we see a rare instance where the Supreme Court addresses a question that's not a yes or no answer. The question here is, all right, we know that separate is not equal, especially in public education. So then, so then they ask 2 questions. The first one is, who's responsible for desegregating the schools pursuant to the decision in Brown? And then, what was the time frame? So to the first question we see, who would be responsible for desegregating the school pursuant to Brown? For them, they said it's the local school board. It's up to local control. And for the time frame, I see that there's a lot of glare now for some reason. It's a little better. Anyway, for the time frame, they use, quote, the phrase, with all deliberate speed, and it was a unanimous decision, which is important to note because of something that I'll tell you in a minute. So in the opinion here of the second case of Brown v. Board of Education, we see that SCOTUS really honing on the fact that locals having control over how this is implemented is important, because it was a really sensitive issue. Okay. The other thing was, though, they understood that locals would, in often cases, not have the incentive to do anything, right? So in that instance, they provided federal oversight. Local school districts would come up with a plan, they would implement the plan, and then the plans would be overseen by federal district courts, because they were closest to the locals, and that they would best know how to kind of address the situation and the time frame and everything. Now, there was a lot of resistance to Brown's ruling, which that was your assignment for this week, to talk about why there would be, why it was delayed so much. Sorry, let me go back here. And the primary reason is that SCOTUS had no enforcement power, and they also didn't really have congressmen on their side at the time, or the executive branch on their side at the time too. But Warren remained really steadfast in holding to these decisions, even in the face of people were literally holding up the signs of Earl Warren saying, impeach Warren, which is really interesting, because I'm not sure that a lot of people can name the current Supreme Court justice. Can you name the current Supreme Court justice, Trent?
Which one? The chief?
Yeah, sorry, the chief. Yeah.
It's Kennedy, right? Roberts.
He's kidding. It was Roberts, yeah. Anyway, but most people probably, couldn't do that. But I know you all can, probably. Okay. Oh, and because Warren was so insistent on just being really steadfast in holding to this, schools need to be desegregated, all these cases kept coming up for the Supreme Court, and there were some really interesting ways that the states tried to circumvent the Brown ruling. In the first case here, we see, so after the Little Rock 9 happened in Arkansas, it prompted Arkansas officials to say, you know what, district court, we probably need a little more time. With all due deliberate speed for us doesn't really mean soon. It means maybe postpone the decision or the implementation for like a couple of years. And SCOTUS ruled no. Because clearly what's happening here, it's not that the community's not ready, it's that government officials aren't ready to implement it. And government officials need to get over it. Then we see Griffin v. Prince Edward County School Board. And this is an instance where a Virginia county actually quit collecting taxes in one school district. And so it wasn't funded. And so the school closed down. So then there were a bunch of private schools that were opening up, and the private schools didn't allow African Americans to go. So this was challenged by the Supreme Court, and the Supreme Court said no. So they're saying no over and over again to these dilatory tactics that states use to try to, well, the southern states used to try to overcome the Brown v. Board decision. All right, now, so with all of these dilatory tactics, we see here that the Supreme Court has to really get into the nitty-gritty details of how this implementation is, because Warren has already kind of set the stage. Now, in 1971, this is the Burger Court. Warren's gone, all right? So it's going to be interesting to see how the Burger Court handles this. And in this particular instance, we see, so North Carolina they have an issue of de facto segregation. De jure, de facto segregation. De jure meaning that the law has created segregation. De facto meaning that it's just, by our own cultural habits and circumstances, segregation is occurring. And what they find though here is that, let me start with a question. Can the federal district court outline a plan for the school board to follow when implementing Brown's desegregation order? Now, this may seem like an entirely different question from what I just brought up, or unrelated to the case facts that I just brought up. The issue was that, yes, they were dealing with de facto segregation. And they all agreed they wanted to find some way to address the segregation that was happening, even though it was de facto segregation. What the groups didn't agree on was how to address it. And there were questions brought up about busing and about drawing new district lines. There was all kinds of things, and they couldn't decide. And when they went before the district court said, all right, we're going to bring in an expert, and they're going to decide. So the district court did. And they decided that busing would be the solution here. So this county, Charlotte-Mecklenburg Board of Education, this new school system, they were upset. Not because they were being told to desegregate, but because they felt like the federal courts were kind of involving themselves too much in an area that was clearly supposed to be state and local jurisdiction. So the significance here is that Berger finally was able to outline proper guidelines of what's the role of the court and what's the role of the local school boards here whenever they're trying to implement this. Now here's what they found. They found primarily school boards, when they fail to meet their obligations to eradicate de jure segregation, the federal courts need to step in. So basically, the courts can step in when the school board's not really meeting the obligation that's put upon them to desegregate. The other thing that they note here is that there might be instances where there's one race schools. And these instances may not be because of de jure segregation, it may be because of de facto segregation. Now, de facto segregation doesn't necessarily mean that it's unconstitutional. What it does mean, though, is that it takes a lot to really unpack whether or not something is de facto segregation or whether or not something is just de facto segregation because it came out of de jure segregation, if that makes sense. A couple other things this case is known for. One, it talks about racial balancing. So, yes, school districts can use quotas, but they have to have a limited use, right? So the idea of numbers just for the sake of numbers is not okay. There has to be a goal, right? And that goal is if numbers can help get somebody to the remedy of getting rid of the vestiges of racial discrimination, then by all means implement it. But the court said just implementing the numbers can't be the end. That just has to be the means. They also talk about racial gerrymandering and mandatory busing. And I'm going to skip over that because we're running out of time and Trent's getting bored, and I know you guys are too. Anyway, the holding is, yes, we see the district court here was able to create a plan that they were supposed to follow. So all that's constitutional. Now, the next case that we're going to go on over focuses on how the modern SCOTUS treats racial discrimination, specifically when there's too much emphasis on integrating race into public schools, or on racial integration. Yeah, okay. It'll make sense in a second. Before we get into the next case in your book, I do want to mention that very briefly, your authors mentioned Greta v. Bollinger. And this is an instance where we see a white young woman. This was in 1997, but the case didn't get up to the Supreme Court until 2003. Of course, it wasn't her admittance that was in question. The question was, she was denied admittance because of her race, and the school admitted it. They had these quotas that they put in place. She was a good student. She had a GPA of 3.8 and a 161 LSAT score, which is really good. So she argued that the general admissions process that they used, because they focus on race, it was actually anti-equal protection and anti-Title VI of the Civil Rights Act. Now, we're looking at strict scrutiny here, so there has to be a compelling interest. And so University of Michigan said, well, our compelling interest is to achieve critical mass in the student body. Critical mass meaning that there would be enough minorities so that they could feel they had a say or a place in education there. And there's this idea in identity politics isn't really the right term, but you can look at it as identity politics, I suppose. There's this idea that there's a certain amount of balance that there has to be in order for a minority to really feel included. Anyway, the Supreme Court said, you know what, University of Michigan, you're right. This is not racial balancing. This is not about specific numbers or quotas. You're trying to achieve critical mass, and critical mass is all about trying to get to that point where all vestiges of racial discrimination are done away with. And the plan that you put in place to achieve this, yeah, I know I'm going over. The plan that we put in place to achieve, I'm going over on the time, to achieve this was narrowly tailored. So moving on. All right, so Meredith Jefferson County BOE, which is Board of Education. This was actually an encapsulation of two cases. One, the parents involved in community schools. That's a group of parents that name themselves Parents Involved in Community Schools. I guess they ran out of PICS. They could have been PICS. Anyway, PICS v. Seattle School District, number 1. Wow, so much.
Who's Chantal?
Seattle. It wouldn't be my lecture if there wasn't typos in the slides. I'm going to fix that, though. All right, so this woman, Crystal Meredith, in Jefferson County, shout out Louisville, what? So, well, I mean, it's Kentucky. So Jefferson County is Louisville, Kentucky. And I have my Kentucky Wildcat shirt on, and I have my Diet Dr. Pepper and my Go Cats.
Yeah, we don't like Louisville.
We don't like Louisville, but it's in Kentucky, so it gets a shout out.
Technically.
It's technically, even though I feel like it's I'm not going to talk about this.
Yeah,
okay.
Was Crystal Meredith's son white or black?
That's a really good question. Crystal Meredith's son was denied a transfer to another school because it would generate a racial imbalance. He was a white child. Now, there was a really similar case in Seattle, and that's why the Supreme Court pulled these cases together. It was all about racial imbalance. So what was the school doing here? Were they really trying to achieve critical mass, or trying to get rid of all vestiges of racial discrimination, or were they just kind of racial balancing? Let's look. The significance of this case is that so let me go up and ask a question. Can government consider race as a criteria when assigning students to a public school? No. They can't. The significance of this case is that the court noticed that these schools in particular were placing too much emphasis on race. Specifically, these school districts had already been ruled by their district courts that they were compliant with getting rid of all vestiges of racial discrimination, right? And so, since they had already been deemed that their school districts had achieved it, them continuing to deny students to go to certain schools based on race was just straight up racial balancing. So, the ruling means that plans to further diversification in a school system has to be necessary. There has to be a reason why you have quotas or a particular number that you're trying to get to. And if you've already been deemed as being, compliant in the Brown v. Board of Education decision, right? And then there's a lot of burden of proof then after the fact to prove that your continued use of quotas are actually achieving a goal. So basically what they found here was SCOTUS notes that what was happening in Seattle and what was happening in Louisville or Jefferson County were, while they were calling it, we want to see the benefits of racial diversification, SCOTUS says, no, because if you were, your plan would be tailored differently. It wouldn't focus on race. Instead, your plan is too narrowly focused on achieving a certain amount of numbers, and it's not on the overall goal of achieving racial equality. And so because of that, what you're doing is racial balancing. You're just calling it something different. All right, now, we talked about discrimination, so we need to talk about the second prong when the court is looking at cases for equal protection laws, and the other half of that is state action. So discrimination and state action must be proven for unlawful government discrimination, but there's been some difficulty in determining what constitutes state action. So specifically, I'm going to tell you about Shelley v. Kramer. This is a case where state laws, again, the 14th Amendment says that states can't promote laws or support laws or enact laws or anything that promotes racial segregation, okay? There were some states, though, that for a while were allowing laws that segregated people in housing. So in certain houses, it allowed individuals to segregate based on race, okay? And it was like it codified in the state law. Now, the NCAACP had their eye on this law for a while, and they decided that they were going to try to really go after it, and they did, and they won. So here's what we see. Actually, I need to give you some more information.
Go for it.
Okay, so
I'm here for it.
So anyway, the states impose those laws, and we already know those laws are unconstitutional, but the states then found a way to get around it. Individuals, whenever, like in suburbs and in neighborhoods, we saw all of these neighbors signing what are referred to as restrictive housing covenants. These are basically private contracts between individuals that if you buy a house in this neighborhood, you're going to agree to not sell it to a non-white person after the fact. So it's a private contract, it's not a state contract. And so they thought they'd gotten around it. The NAACP found a way to link it to state action. Here's what they found. So, a white neighborhood in St. Louis, Missouri, had a restrictive covenant since 1911. The covenant stipulated that houses, I didn't say that right. The covenant stipulated that houses would only be sold to Caucasian individuals. Shelley here, a black couple, JD and Ethel, purchased a house in the neighborhood. And then we have Lewis and Fran Kramer. They were sued in local court because... Yeah, okay. So they weren't going to sell the home to the Shelleys. Kramers weren't. They bring it to the Missouri State Supreme Court, and the Missouri State Supreme Court held up the contract because it was a private contract. Okay, so now these restrictive housing contracts are now all of a sudden involved in state action. You see where they're getting at here? Yeah, he sees. Mm-hmm. This is Kramer.
It's actually him. Wow.
So Shelley v. Kramer, 1948. The question is, are court-enforced restrictive covenants a violation of the Equal Protection Clause? People thought the court would say no, but they didn't. They said yes. Why did they say yes? Because if it's the kind of thing that the courts would have to uphold, then it's a legally binding issue. It's something that the states must support. So we see Shelley v. Kramer actually expanded the definition of state action. Now, many thought that SCOTUS' decision here was really an overreach, that the intentions of those who framed and ratified the Equal Protection Clause within the 14th Amendment intended it to apply to states, not individuals. Since then, we see kind of some mixed rulings from SCOTUS in terms of what is state action and what isn't. In Burton v. Wilmington in 1961, we see SCOTUS. They try to continue the precedent that state action occurs when there's this clear interaction or intertwining of state and private affairs. Then in another case, in 1972, there still is an intertwining of private and state affairs, and yet they rule in favor of the private entity. So I was going to say the Supreme Court rulings are like a box of chocolates. You never know what you're going to get, but that's actually not true, because the court has been overall, with the exception of state, well, actually no, they have been very firm in upholding strict scrutiny when it comes to race discrimination. Do you have any questions? No, because you're ready for class to end. So are you, and so am I. So, also, remember, you guys, if you have any questions, to please email me. If you're having any issues with the class, email me. Maybe I can help. But, okay.